Well, we might as well get started. We'll benefit the people that are here already. So thank you for joining us. We have another class today. This one is potentially a little different than what we would normally do. We're going to do it on rentals, but I think I titled this class Rentals When Selling. It actually is a thing. So, Mike, you and I talked about this briefly this morning when I tried to give you a heads up on the topic. But basically, what I've always encountered is that agents like to consider themselves either they do rentals or they don't. And I
Hmm.
would argue that it's actually not that simple. That if you are doing a sale and there's a tenant involved, or the buyer wants to be a landlord, or it's seasonal, or whatever it may be, guess what? You're doing rentals. Even though you don't consider yourself a rental agent, you are one. And there are some important tricks to remember, some quick things that we can get you 90% of the way there. And then you can lean on other people, other industry experts, either attorneys or brokers, to help you with the rest of it. So that's kind of the idea on this topic. And I wanted to start right from the beginning as we look at the contracts themselves. And I will share my screen real quick. I probably should have pulled this up before. But if you look at a NABOR contract, as is or standard, and FARBAR kind of has the same thing, it actually has a section in here on possession. So the standard would be that possession is due at closing. So once you are closed, the seller is obligated to transfer possession over to you. But rentals, someone else has possession. And Dad, just generally, can you terminate a listing agreement or a lease agreement just because the property's sold? Is that a fair
No,
assumption?
unless it's a portion of the lease, and that's rare. When I
Very
have seen
rare.
it, the landlord would have to give 30, 60 days notice of the termination, but that again is rare.
It is rare. As a general rule, the fact that you could terminate a lease just because there's a sale, it doesn't really work that way. Even a
No.
foreclosure, that lease, if it's a valid lease, the tenant has right of possession, even if someone else has the ownership, even if that transfers. So that's a good thing to remember. And if you look here at what I'm sharing, Section 7 is existing leases with post-closing occupancy. So if this box is checked, the property is subject to one or more leases and rental agreements in effect as of the effective date.
Mhm.
Seller shall deliver complete information regarding the terms of said leases and copies of all written leases to buyer not later than 5 days after the effective date. Buyer shall have 5 days after receipt of the lease information to review and may terminate the contract not later than 5 days after receipt of the lease in buyer's sole discretion if it's considered unacceptable. If seller fails to timely deliver, buyer may terminate this contract not later than 10 days after the effective date. You know what that looks like, Dad? It looks like an as-is contract.
Well, it is. It's, to the extent you have a lease, it is.
Yeah. And obviously this particular contract is as is, but the standard form works the exact same way. If there's a lease, if you check this box, it's an as-is contract because the buyer's going to be given at least 5 days to review the lease in their sole discretion, and they can either terminate or continue forward. So similar to some other scenarios like condos, where there's a condo review period, or even like extended deposit agreements, if there's an existing lease on the property and you plan on checking this box, you should probably use an as-is contract anyways, because you're not really benefiting yourself. You're not benefiting the seller by requiring a standard form. So that would be my argument to using an as-is contract. You're giving them one anyways. So that's the first part. And I put up on my board, you guys can't see it, but I've got a whole list of things I wanted to talk about. So possession at closing. And Dad, would you say that's kind of standard across the country, that possession at closing is a pretty normal thing?
Yes, yes,
Yeah.
it absolutely is.
Yeah, it's not a loaded question. That's pretty normal.
I mean, it
When
goes
you
back
pay
to
for it, you
basic
get it.
they would exchange a piece of dirt for the cow or the money, whatever the other consideration was. So
Yeah.
it's
And Mike, you brought up a question before. You said, look, it's possible that that's why you're buying this property, is that you want to review the lease and you want that rental income. Absolutely. Absolutely. And that's a big part of commercial property as well. Dad, you and I are doing a closing right now. There's 8 tenants on a commercial property, and
I'm sorry, Chris. You're
yeah,
busy.
yeah, it's a lot of work
Great.
because on each tenant, you have to review the lease, review security deposits, prepaid rent, tenant improvement allowances, and you have to reimburse the buyer for any money that you're going to owe the tenant in the future. And that can really be significant. You could be giving a tenant 50 or $100,000 back, when their lease expires. And if the buyer's not aware of that, or if it's not calculated correctly, it could be really intense. I would say commercial real estate agents know this very well, and it's a big part of what's different between commercial and residential is that almost every deal is going to have tenancies involved of that nature.
Christian, my number one problem with rentals usually happens before the closing. And the problem is a lot of tenants don't want you to show the property. They like the living there, they're worried about things disappearing, etc. So it can be very difficult, depending on the tenant, on whether or not an agent that wants to show the property can actually get in there and show it. And
Yeah.
that's a conversation you have to have with the owner of the property, that if you're having difficulty there as listing agent, you need to bring that to a head with the landlord and let them figure out how to address that.
Yeah, it's a great point. It's a great point because that's something that could sabotage a deal. If you give a tenant too much leverage, they could renegotiate with you just so that you have access. It sounds a little silly, but most leases have a language in the lease that says that upon notice, the landlord can show the property, can walk the property and do all these things. So contractually, the tenant can't say no, at least as
Well,
long
it's
as the landlord's
contractually
being.
and statutorily. If it's silent in the lease, you have Chapter 83 that allows reasonable notice, and they get into definitions. But the problem that Mike and I have run into quite a bit is when the tenant just says, no, we disagree, or we have COVID, or we had one where the lady we found out was blind, and that was a whole nother issue.
Yeah. So
So
what do you do then? What's your recourse in that
the
scenario?
only recourse is to go to court, but that doesn't help you with a contract.
No,
The
no.
buyer knows you have a
Yeah.
difficult tenant.
Right.
You know
And
what?
you're hiring an attorney, you're spending court fees, you're delaying things. Yeah, Mike.
You know what I had to do with one of my rentals? I actually paid the tenant for every time they allowed a showing. It was worth it to me. Rather than get attorneys involved and all that, if I paid them $50 a showing, I knew it was going to go under contract quickly.
Yeah.
It was the cheapest avenue to resolve a problem.
It
Yeah,
sure beats a
and
HUD complaint, right, Mike?
I've done that before. I had a tenant who had kids on the property, and it was they all the time they wanted the showing during the weekend, which is when they're using the property, and so the landlord actually suggested, hey. I'll pay for you to stay at a hotel Saturday night. They have a pool, they have facilities, and you just have to give me, from noon on Saturday to noon on Sunday. But I'll pay your hotel. You can have a little staycation somewhere. A water park. I had a client suggest that they would pay for a water park outing, Disney World, things like that. Hopefully, it doesn't get to that point. It really shouldn't. But Mike, to your point, it's a really good way to make it a smooth process because the tenant could sabotage the deal. They could make the place a mess. They could break things. They could be difficult about filling out a tenant estoppel letter, all those. And if you can avoid that by just, cheap insurance, $50, that's not bad. That's not bad. That's a great suggestion. So
I've run into situations, Christian, where the shoe was on the other foot. The tenant signed a lease not knowing the property was listed for sale. And then like day one after they signed the lease, the landlord wanted to show the property. So, that it can go in the other direction.
yeah, now the tenant feels pretty bitter. They feel manipulated almost, but it shouldn't matter, but it does. The tenant just moved in, they spent a bunch of money on movers or whatever it may be. I get that. That makes a lot of sense. So keep in mind, that tenant, even if contractually you have every right to do this, it requires a lot more hand holding and kind of persuasion than you might think. And a good listing agent should do that in advance, well before you do any sort of actual showings or put it on the market. So that's kind of the big part. And you can tell already that, if you're a listing agent, you're a buyer's agent, these tenants, they matter. They are a big piece that you otherwise don't have to deal with. So keep in mind, that's a good reminder. So, all right, let's say you make an offer. This box is checked, you get it signed, and now the tenant sends you, or the landlord sends you everything they have, and you do an inspection, and you're doing this, you get a survey. You think you should review that lease, Dad? Does that sound like a good idea?
Well, you want to review the lease, but you also want to talk to the tenant, and the owners resist that. That they don't want you putting the fear of God into the tenant until the second deposit is down. So I run into a lot of issues. I mean, I advise all my buyers, you talk to the tenant. Are they a good tenant? Are they happy there? I mean, when is the lease expiring? And the owner, on the other hand, they don't want to lose their tenant if the buyer isn't going to put their second deposit down. So there's a big tug of war over that. Looking at the leases, you absolutely have to look at that. But evaluating the behavior of the tenant, and is the tenant happy with the landlord? Does he have any outstanding claims against the landlord? Is a big deal.
How do you know if you have the most recent copy of the lease if you're not allowed to talk to the tenant until after your second deposit?
Well, you don't, but then that would be a reason to get out of the contract, because paragraph 7 allows you to look at the most
So I
recent.
mentioned this term before, and I didn't expound on it, but a tenant estoppel letter. So you may be familiar with estoppel letters for associations, where they
Right.
detail, what the fees are and what, how the seller is maintained their account and things like that, what the transfer fees, things like that. Well, tenant estoppel letter does the exact same thing, but for a lease. So as a good listing agent, what I would recommend is you have a copy of the lease, any amendments, any additions, and then you also get the tenant to sign an estoppel letter prior to going live. And the estoppel letter is dated more recently, maybe within the last week or two. And it says, I have a valid lease dated September 1st, 2022. I pay this amount every month. This was my security deposit. Here's who's living at the property, and here are the pets that I have. And this is when the lease expires. And that's a wonderful form because it's dated more recently, hopefully within the last 30, 60 days. And then it basically confirms or warranties what that lease said, that you have the right information. And it's helpful for the landlord too. It's a very powerful tool.
It's nice too to find out whether or not the tenant has any outstanding claims against the landlord, because there's a tendency of landlords to dip into the security deposit if there's something that the tenant broke. I mean, the landlord might have a valid legal reason to do so, but they didn't go through the proper steps. So there might be a disagreement on what the amount of the escrow or the deposit is on the lease.
Mike, you've heard of those tenant estoppel letters. In fact, I think you and I had to sign estoppel letters for our landlord for the business, where we had to specify, because he was getting a new mortgage, and so we had to sign something that the lender could rely on, saying, "Here's what we pay. Here's when our lease expires," so on and so forth.
True. And you got to think very carefully when you're filling that out, because you don't want to make any errors. But
Right.
a thought popped into my head. We've been talking about how the tenant could be a problem as far as getting it under contract and closed. Sometimes the tenant could be an asset, because if the tenant has kept the property in good condition and maybe has a nice lease in place, where particularly if you have declining rental rates, that lease all of a sudden might be desirable to the new buyer.
Yeah.
And the other thing I would look at if I'm a potential buyer is, what kind of security deposit do they have up? Because some people, when they rent their property, for some reason they don't think as much about the security deposit, and yet that could be a crucial component.
Yeah, absolutely. All these things matter. In fact, someone mentioned sellers often want to keep the listing a secret from tenants. And I understand that, if they believe that the tenant's going to be upset, they don't want to, rock the boat, especially if they, aren't going to actually sell, if they're just kind of putting it out there. But to me, I can't imagine not having that conversation with the tenant. Number one, the tenant can't stop you. It's your right. And if there's going to be a problem, you need to know in advance. You can't let that surprise you later on, because if you don't deal with it before you list it, it's only going to be worse, because you're going to have time constraints. You're going to have, legal constraints if you wait until the last second. So I had a deal last year. It was, I gave the seller this same spiel, and I said, you can't avoid this. You don't put it off. And he chose to. He said, no, I don't want to upset him. He's kind of difficult and he's been there a long time. And, let's see if we get a good offer. Well, he gets a good offer, and then he can't close because the tenant won't get out. The tenant refuses to leave. The closing got delayed 6 months. The seller had to give the buyer all of the rental income in those 6 months just to keep the buyer in the deal. So it cost him thousands of dollars. I think he had to give the tenant his deposit back early, had to help him pay for the move. I think he waived like a month or two of rent. It was a mess, and it was all because the tenant had leverage.
Let me give you another nightmare. What if the tenant is behind on the payments?
Yeah, it's a mess. And that's where the tenant estoppel letter is really powerful, because, they'll specify in there whether they're in default or not. It's something like that. Or here was my last payment. And imagine, Mike, if a landlord was, motivated to sell and said, no, tenants paid everything. They're up to date, and they haven't been. And then the buyer comes to find out, oh, this tenant hasn't been paying for 3 months, and now that I'm closed, the seller misled me. That's fraud. Yep. That's really bad, especially if that was supposed to be a great lease. If that was one of the reasons you were buying it, that's a huge mess. That's a mess. Don't do that. Don't do that. All right, so definitely review the lease. It's very important. Review a tenant estoppel letter, also very important. I would require that as part of your offer. And as a listing agent, that I would expect to provide that. We've talked about accounting for deposits. We've talked about rentals, or the rental income. If someone is prepaid, so most rentals you're paying at the beginning of the month for that month. But you may have also paid first and last when you first signed up. So there could be the prorated amount for October, because we're October 11th. So you could have the prorated amount for October that you owe the buyer because the tenant prepaid, and their last month, which could be another $2,500 or whatever the rental is, plus whatever the deposit might have been, which maybe is another $2,500. So the seller could owe the buyer, $6,000, $7,000 in that scenario. And I think you got to do that research ahead of time. You got to have a spreadsheet. You got to know exactly what the buyer paid. They want to know the rent roll, that sort of stuff. All right, this is a big one. What if you're getting a loan? So now you're the buyer. You're totally okay with the tenant being there. You reviewed the lease. You even talked to the tenant. Seems like a good guy. Everything seems great. I'm okay with everything. And the tenant has 6 months left on his lease. And then once that tenant leaves, the buyer's going to move in. Sounds nice, right? Except for one problem. You're most likely wanting to get a primary home mortgage.
Right.
So it matters if you can move in within 60 days. On every loan document that you get, you sign a form saying whether it's going to be owner occupied, a second home, or an investment property. And if it's that first box, owner occupied, the buyer must move in. They have the intent to move in within 60 days of closing. And if you have a tenant who has a 6-month lease, we got a problem. That's potentially mortgage fraud. Have you seen that before, Dad?
Oh God, yeah. They won't get the mortgage if
they won't get the mortgage. Yeah,
they just get it. So you run into cash for keys. Can you get the person out? Again, when is the second deposit due? I mean, that could be a deal breaker for sure.
Could be a deal breaker. We had a deal, and we have talked about it on this video before, when you're negotiating post-closing occupancy and you give the seller 90 days or 120 days, because you're not planning to be there anyways. You live in Canada or California, you're coming down in the winter. So that seems fine, except if you're getting a primary mortgage. It's a mess. So Jackie actually had a follow-up to our previous talk. Was that tenant month to month? So that was the tenant that kind of delayed closing like 6 months and he was difficult. If so, could he have given the difficult tenant the legal notice of 30 or 60 days? So yes, Jackie, he actually was month to month, but the requirement, you can't physically remove a tenant, right, Dad? Do you want to give us a quick
No,
synopsis on how that works?
there's no self-help. You have to actually evict them, and with month to month, you got to give them 15 days notice prior to the end of the month, assuming the payments are due at the beginning of the month, and then go to court. And then you
Then
get the
go to
order from the
court.
judge,
Yeah.
and the sheriff will, physically evict the person because they don't want to have physical altercations. If you show up on a Friday night and tell a man and his family that he needs to get out, I mean,
Yeah,
that's
they don't want that, and it's illegal. The
no.
landlord could get themselves in a lot of hot water.
And that
So,
falls into
Jackie, in
deluxe
this
too.
scenario, the landlord knew that. I advised him that he couldn't make those steps. And so they did give notice. They did file the eviction, and it took forever. It was like 90 days, and the landlord just decided instead to negotiate with the tenant and say, look, I don't want to go this eviction route either, but let's do X, Y, and Z. If you're out by this time, then I'll give you this money. And he basically just greased his wheels. It's called cash for keys. It's a great tool because if you have to spend $2,500 to an attorney, might as well give that $2,500 to the tenant and get him out on Friday, as opposed to 60 or 90 days from now. So great question, Jackie. That's the problem, is that contractually, yes, you're right. But in practice, it takes a lot longer. You got to go the legal route, and it can be, in the meantime, you're trying to close in 2 weeks or whatever it was.
Yeah, people break contracts all the time. The cash for keys not only helps save on the attorney's fees, but it also helps get the landlord possession of the property quicker, and it helps ensure that the property will be left in good condition because the tenant's going to want their deposit back. So, if you look at all three of those elements, the owner actually saves money by paying some money to the tenant. It's a heck of a lot cheaper than the lawyer. They got possession earlier, so they can have their closing and get their cash, and they get a place that doesn't have the holes in the wall and components stolen and things like that. So it's definitely a winner.
So, Dad, I don't know if my brother told you this, but he had a tenant who left, and they ripped all the copper wiring out of the walls before they left because they were angry, or they just were, who knows.
I haven't heard
So
that.
that's what we're trying to
brother?
avoid. So cash for keys, give them the money, make them happy, even if it kind of hurts your ego to pay them for it. And I would say that's the hardest part, is a lot of times when you have a tenant who's maybe late on payments, or gives you a hard time, or doesn't take care of the property, contractually they probably owe you something, but in practice you should owe them something. And
They get angry. It's home. We actually had a tenant who stole an air conditioner. We had a tenant who we did not know was blind, but was blind, and after the transaction occurred, filed a HUD complaint, which was a living nightmare. You do not want to go through a HUD complaint. So, it's definitely worth money to spend a little bit to get a lot more.
Yeah, and the other thing that you might want to do is, let's say the buyer is getting that mortgage and they have a rate lock expiring and the tenant's giving them a hard time. The buyer may say, well, look, let's do this. I'll take possession, or I'll buy the property, and I'll get the tenant out, right? I'll take the rental income. But just be careful. Being a landlord is very different than using it as your primary home or a second home. If you don't intend on being a landlord, I wouldn't wade into it. I wouldn't voluntarily say, oh, I'll be a landlord for 6 months. What's the worst that could happen? I would rather just delay closing, wait, give the seller that headache, let the seller deal with it, and then take possession when the tenant's gone. Mike, you've been a landlord for a long time. Do you have any of those kind of war stories, or any like tips and
I got a
tricks for people?
couple of them. One little issue, but it can be kind of a sticky issue, is if you are a real estate agent and you represent the buyer,
Okay.
a lot of times the tenant will vacate so you can close, but they're not thinking about the garage door clicker that's still in their car. They're not thinking about the mailbox key if they're in a condo
Right.
project. So that's a little thing that kind of miffs the buyer going in. But if you're the real estate agent, maybe you can bring that to a head by talking with the other side and make sure that you've got that covered. My war story was with one of my properties. The tenant wanted to bring their comfort animal in, which was a 50-pound pig.
Okay, comfort animal. Okay.
That was an interesting one. I kind of knew the rules and all that. And when they decided they did not like my unit and wanted to rent elsewhere, I got to admit I was kind of smiling.
Comfort animal, huh?
Comfort animal. We did a whole video on service animals and emotional support animals. I did not mention the word comfort animal, but it kind of works that same. If you want, you can take a look at that video in the future. But if we keep going on this, seasonal rentals is the next hot topic that I want to address. And this actually can be quite challenging. So in this scenario, you've got a property where the sellers have been renting it out seasonally for years. That it's worked pretty well. Some tenants are repeat, other ones are brand new. They do anything from a couple of weeks to a couple of months, but they're considered seasonal. They're not annual. There may not even be anyone in the property at the time of closing. But you still need to go through all these same steps. You still need to share the rentals, the lease agreements with the potential buyer. You need to notify the tenants of this change. I wrote down a couple of points also. You're going to have to coordinate with the rental agent that's involved, because that could be someone different than who the leasing agent is or the listing agent. You've got a lot of things that you have to worry about. In addition, you've got potential Airbnb or Verbo issues. So we've run into this not all the time, but it does happen. If you have a seller who's renting it out on Airbnb, you can't easily transfer the account from the seller to the buyer. In fact, they change this frequently, so I may not be 100% correct. But what we've had to do in the past is the seller cancels their Airbnb account, and then the buyer gets a new one, and Airbnb sometimes will allow you to transfer it, but most of the time they make you sign a whole new lease. So you might lose that tenant. It's just very complex. I even had one where the seller had to continue their Airbnb account after closing, collected all the money, but the money wasn't released to the seller until the tenant actually stayed there. So closing happens, the money is at Airbnb, the seller cannot terminate their agreement with them, so that a month later the tenant uses the property, everything goes well, tenant gets their deposit back, seller gets the revenue, seller gets the money. And I think we may have held money in escrow or something until that was released. But it's complex, and it required spreadsheets, especially when you have more than one tenancy like that. I would say that's probably the most challenging part of these leases, is when you have a third party service like that, because there are rules and there are guidelines and there are fees and all that. Robert mentions, have you seen an increase of Airbnb landlords wanting to sell their properties now that they are not cash flowing like they did during the pandemic? I haven't heard anyone tell me that yet.
No.
It doesn't mean it's not happening, but we've done it's. I would say the majority of our closings that we see are used as seasonal, use by the homeowner. So I did a closing this morning for someone. They're from north of Toronto. They come down here for 6 months a year when it's too cold up north. And now that they're not using as much, they're selling and they're downsizing a little bit. I would say that's the majority. It doesn't, and then the next is people that use it for their primary residence, and then the next would be landlords and rentals. But yeah, I agree. If you've got a variable interest rate loan that went from 3% back during COVID days, and now it's at 7 or 8% for that same rental, yeah, those landlords are going to sell. Absolutely. They're not cash flowing. But if you have a locked in fixed rate people are probably holding on to them. Those are like gold, I would think.
The
Um,
properties are still appreciating though, regardless of the rent. I mean, down here, it's appreciation is probably more significant than the cash flow, I would think.
Yeah, well,
You look at your own home in
you
the
have to
last
look at
couple of
both.
years.
So actually, I love this topic. This is something that I always think about. This is where my brain goes. You've got how much money you have invested on the deal as opposed to the total purchase price on
Right.
evaluating what your income or your return on investment is. So we'll give you a scenario. Let's
It's
say
like a
it's a
stock.
yeah, it's like a stock, but it's a leveraged stock in a lot of cases. So let's say it's
Yes.
a $200,000 property and you pay $200,000 in cash for it. And so if you wanted a 10% return on your money, you need to be able to make $20,000 a year in income. That's, net income, hopefully. That's your 10% return on that return. But let's say you take that same $200,000 deal and you buy $1 million property. So you're putting 20% down, you're borrowing the rest. You still need a 10% return on your money, which is 10% on the 200,000. Plus, you're going to have to cover your interest cost on the loan. So you're going to, you can do the math, but it's kind of fun to think, all right, I take my same 200,000, should I leverage it and buy $1 million property or should I pay cash? Which one's going to get me the better return?
Oh,
If
but
you're calculating the appreciation on the real estate, let's say the $200,000 property is getting a 5% return on the appreciation and the $1 million property is getting a 5% return on appreciation. You're going to go for the $1 million one because 5% on a million is going to help you out a lot more.
yeah, I mean, I would tend to go for the appreciation because it's not taxable now, number one, and two is what's the difference between that and say Apple stock or Nvidia or anything else? It goes up in value. You can hold it. If you're looking for a 10% return, this part of the country is totally different than say, North Carolina, where your uncle used to live, where he sold the property for the same price he bought it for 5 years earlier. There was no difference in appreciation whatsoever
Yeah.
versus your home or my home over the last 5 years or anybody's home in Collier County. Has it gone up in the last 5 years? And I
Hey,
would say,
Mike,
yeah.
let me be devil's advocate and get your opinion on this. Is being a landlord the same as owning Apple stock in your mind?
Oh,
No,
God.
a lot more worries.
It's a lot more worries, right? It's a lot more work. It is not usually passive income.
No,
Even
I'm
if
just saying you got to
I'm just
consider.
being devil's advocate, but like I always want to warn landlords, it's not the same. It could earn you more money because you have more opportunity to leverage the property. You
Right.
could know more about real estate than you do Apple stock. If you're in this business, like a lot of the viewers are, this could be absolutely the way you should do it because you're doing it anyways. This is your business. But
Well,
if
and the
you
other,
want something with no strings attached, buying Apple stock might be a little easier.
But back to the original question with the Airbnb, are we seeing an increase of sales? I would have to wonder, does that owner look at the so-called appreciation in value? Is that a factor?
Yeah, yeah, absolutely. Mike, did you have something else?
one of the interesting dilemmas you face as a landlord is if you have a good tenant in place. And I had a lady who was in her 90s who just kept the property in mint condition. When it comes time to renewing the lease, sometimes it's better off to have a nice tenant in place that cares for the property than it is to get maximum top dollar in the lease. I'd much rather have someone that takes care of the property than someone else that's paying $100 more a month, and yet they're not taking care of the property. And maybe
Yeah.
they're a chain smoker or whatever. I mean, it just
Well, and that's the realities of this is that, you could believe that the property can fetch 2,200 bucks a month on rent, but the reality is getting someone at 1,800 a month could be a lot safer. I had this conversation with someone who was trying to determine, do I do seasonal rentals or do I do a long-term rental? And I said, look, seasonal is a different game. It's a lot more work. You're initiating a new tenant every week potentially or every other day. Whereas
Mhm.
the long term, you might not hear from them for a month or two. And that's pretty nice. So, what's the value of your time and your input? Also, Mike, I'm under the belief that seasonal rental agents, property managers, they charge much more when it's short-term rental than if it was a long-term, right? So long-term realtor might charge, half a month rent as a commission, whereas a seasonal might charge as much as 30% or more on a seasonal rental.
True.
So Jackie had a follow-up. She said, did I hear correctly that the new owner did not collect on a previously booked short-term rental? I thought that the rentals under the new owner's watch belonged to them. No, not necessarily, Jackie. I would say the standard expectation would be that if you own it during the tenant's occupancy, that's your money.
Sure.
But
Yep.
if I buy it today and the tenant doesn't actually use the property until next month, that's my income, not the seller's. And our job at that point would be to transfer the income from the seller to the buyer. Any deposits, any prepaid rent, that goes to the buyer. Unless, of course, you put that in the listing agreement or the sales contract saying that any previously collected rent shall be, maintained by the seller or kept by the seller. I would say that's not normal though, so I wouldn't expect that. Good point. That was a good one. All right, I've got maybe 3 more things I wanted to hit on, and then we can, go anywhere else we want to go with it. Taxes. Taxes is a fascinating concept for rental properties because you have income. And this income, needs to be dealt with. You might be able to depreciate against it. You might be able to offset it with other expenses. You could have it where you're potentially not paying any taxes between expenses and depreciation and offset your rental income and then just depend on the appreciation, the price appreciation. But you would want to look into it. You'd want to talk with a CPA, someone that can do your taxes and think more creatively than just winging it, because that you could be leaving real money on the table if you don't consider for taxes. The other thing I wanted to talk about is HOA and condo rules. If you have a buyer intending to buy the property and rent it out, they really need to spend time looking at the rules and regulations to make sure that it can be rented. And this is something that I've seen go wrong before. Either the buyer didn't even ask that question, or the realtor forgot to remind them, hey, look, you told me these were rentals. Let's look at the rules.
Right.
I've seen where realtors got blamed later when they weren't allowed to rent the property. And it's like, hey, you knew I was finding rentals and you brought me to this association and now they're telling me I can't rent it. Don't get caught in that. Just make sure you're always reminding your buyer, hey, look at the rules, look at the regulation. Kim makes a good point. They could simply say, yes, you can rent it, no problem, but you have to wait a year for that to kick in. So they want you to own it for a year before allowing it to be rented. My condo unit in Atlanta had that restriction where you had to get on a list. So according to Fannie Mae and Freddie Mac rules, only so much of the property could be rented at any one time. So in order to stay within that limit, once they got to the limit, everyone else went on the list. And it would take about a year for you to get to the top of the list and allow you to rent the property. And anytime it's sold, you went to the bottom of the list again. So that was really important. I even had one deal where the listing agent called the association and confirmed whether they could rent. And the property manager said, yeah, you can rent, no problem. Well, there were 2 problems. One, it had that 1-year restriction. And 2, she called the wrong association. Yeah. She was trying to do a good thing. She was trying to help out the buyer, and it backfired on her. And so, this is something where, again, even if you don't consider yourself a rental agent, all these things we've already talked about, they are very relevant to selling property. Very relevant. The last thing that I want to talk about, pre and post closing occupancy agreements. Dad, generally, is this the same as a rental? Is that essentially what it is?
It's specifically excluded under Chapter 83 as a rental, something occupancy tied to the purchase or sale of real estate. You go to the beginning of Chapter 83, it's excluded, which the downside to that is if you have to get somebody out on a pre or post closing occupancy addendum, you don't get the expedited hearing. You got to wait, a much longer period of time to get them out. So that's the risk.
So legally, post-closing occupancy agreements are not considered a lease. It even says it in the form, hey, this is not a lease. And essentially, the real downside is that if you're not considered a lease, you have a different avenue in court, right? It's potentially a slower avenue.
But it's a regular lawsuit court. You serve the other party, they got 20 days to respond. Somebody files a motion to dismiss. It can take 12 months to resolve a lawsuit, depending upon the ins and outs of it.
So, Dad, you wrote an article over the weekend that I thought was really good in the sense that when using a FAR bar, and maybe it wasn't this past weekend, but when using a FAR bar contract, you don't like using, or you, in one particular example, you didn't like using the FAR bar post-closing occupancy form.
It was a pre-closing occupancy because that one was subject to the attorneys negotiating a lease.
Yeah, so just be careful. That's the point that we wanted to touch on briefly. Not all forms are created equal. So the FAR bar pre-closing occupancy addendum,
different than NABOR.
It's different than NABOR because it says that the parties will negotiate a long-term lease or a lease with these certain expectations. And in the article you wrote, you said, I really wanted to avoid negotiating with someone else's attorney and dragging it out over 2 weeks. Because that's not very fun.
Be easy, and also as my client was the buyer, and if they were going to have a hard time getting my client out, that was a win for me and my client.
So your solution in that case was, let's use a NABOR pre-closing or post-closing occupancy form because doesn't have to be negotiated later. All the terms are settled right then and there when you do your contract. And we're not having to renegotiate 2 weeks after negotiating the first contract.
Yeah, the deal was done when the contract was signed, and the listing agent and the seller did not appreciate that there was no expedited hearing if they had to file to get my client out. They'd have to file for ejectment rather than eviction.
Yeah, exactly, because it's not a lease.
It's not a lease by statute at all. No.
I will say I like the NABOR post-closing occupancy addendum. I think it does a great job, but you really shouldn't use it for long term. I would say a week, maybe 2 weeks, maybe a month, but really the longer the period goes, the more I'm going to want you using a lease. Because if you think about a lease, it's the same as a sales contract. The longer it is, the bigger the agreement is, the number of pages that you have, it's essentially having a better conversation between buyer and seller.
Oh, there's more obligations involved. Who's
more obligations? It's more clarity.
Pool, who's whatever.
And that stuff matters the longer your leases, the longer your occupancy is. So if you've got if you're negotiating a 9-month post-closing occupancy form, I really don't suggest using that one-page NABOR addendum. I think that's a mistake. I wouldn't do that. I would spend time. I would want a security deposit. I would want to know who the tenants are. Is there pets? Who's paying for the cable? Who's cutting the grass? Is there smoking permitted? What if there's a party? Like, kind of want all of that included into a traditional lease because it's just. There's more things that could go wrong on a long-term lease like that, and post-closing occupancy is just not the right fit.
And I know we've talked about this before, but unless it's our client, I don't like pre-closing occupancies. I mean, there's just
so let's talk about that. Yeah, so I'll state the reason I don't like pre-closing occupancy is that the buyer there, and I'll let you talk about why the seller doesn't like pre-closing occupancy, but from a buyer's perspective, the way I wouldn't want a buyer doing it is because they waive their walkthrough rights and seller maintenance obligations in most cases. Yes. So the seller is obligated to maintain the property. They have risk of loss all the way through closing. But if the buyer takes pre-closing occupancy, they're saying, hey, look, I'll take over the maintenance from here on out. And if it's a week in advance, if it's 2 weeks in advance, I would say that's could be a risk. Now, if the buyer still wants that, I think that's great. But where we've leaned to recently is that we carve out, we say, okay, the buyer may be permitted to put this stuff in the garage, but we don't use this pre-closing occupancy form because I don't want the buyer waiving maintenance rights for the seller in the meantime. We're just putting stuff in the garage. So if you find yourself wanting to do something like that, I think you should reach out to us, reach out to an attorney, and negotiate that not using the pre-closing form. Dad, why would a seller not like a pre-closing occupancy
Well, the
form?
buyers, when we get those, I mean, the buyer may not purchase the property. I mean, that's one thing. The longer you go, more things happen. Somebody could get sick, somebody could pass away, the stock market could go south, we have another war, a million things could happen, and they don't close. But typically, when I get one of those, I'll ask, well, why the delay? And there's usually some contingency that we can work around. You can have a closing tomorrow, where the agent gets paid, where we get paid, everybody gets paid, and you can have seller financing for the discrepancy that the buyer can't come up with. That way we'll have less time. Let's say it's a 9-month pre-closing occupancy that they were proposing. You're going to have 9 months worth of phone calls, 9 months of things that could possibly happen that could jeopardize the whole transaction. It takes up a lot of your time, takes a lot of the realtor time, when time they could be spent, selling to
Yeah.
somebody else.
You used to always say, I don't want the buyer finding out what's not so great about the property before they've
Yeah.
actually closed.
What did the inspector miss? You just don't, or something breaks during that time period. If I could in any way get them to close early, even with, again, a seller financing for half the purchase price, I would go with that.
I would too. I would
Get it
not
done.
do, last part of this, I would not do a lease to own agreement. There's too many potential title issues with things like that. Seller, could mess it up so many different times. And it sounds great, if you read it on Google or on YouTube or something, but I would stay away from doing lease to own or something like that. I would just
Oh,
do
they've
seller
got the lease with
financing.
an option to purchase, which is one thing, and then they have installment agreements, which are considered
Yeah,
mortgages
I
under
don't
Florida.
like installment agreements. I don't like lease to own. A lease with the option to purchase, I'm okay with that. That's better. I like that better.
A lease to own could mean one thing in one state and mean something entirely different in Florida, and that's what I typically run into. In other states, you get the deed at the end of the lease, no matter
Yes.
what. And in different states, that if they miss a payment, they automatically don't get the property. In Florida, the owner has to foreclose that lease because it's considered a mortgage.
Yeah, they'd have to evict you and all those things. Ugh.
Yeah.
Mike, any other words of wisdom for us?
Yeah, actually, Don, with the pre-closing occupancy, let me give you a twist to that one. The movers show up a day or two early and they want to put the furniture in the garage. How do you protect yourself if you're the seller? What do you do?
Other than using a gun? Yeah.
Other than using a gun, right? It depends upon the relationship between the parties. Are they friends? I mean, we might mark up the pre-closing occupancy and limit that to just storing furniture in the garage. I've done that, and part of that depends upon how well the parties have gotten along, how the sellers responded to. Has the buyer been on time with deposits? Are they aggressive, or are they friendly? So there's a lot of variables that we look at.
Yeah, it's a really good point, Dad. It does matter if the buyer and seller are friendly, right?
Yes.
So it's hard, we're trained to avoid worst case scenarios and to predict them. And so if we were doing it to do that solely, we would say, oh, get your moving truck out of here.
No way in
Right?
God's green earth. Forget it.
Right. But the seller may think, oh no, Jerry, I don't mind if Jerry does that. No problem. Let's say, all right.
Great.
So now
Okay.
we know the client wants Jerry to move his stuff in. They're friendly, they trust him. We'll throw out a couple of options. We might say, hey, let's sign up some sort of pre-closing occupancy form. Let's release the deposit or put up additional security or collateral. Something like that, where we're not shooting ourselves in the foot just because we feel like we need to be the nice guy.
If
I
you
mean, if the
think
people are
about it,
getting, no, sorry, Mike.
if you think about it, one of the most stressful periods, if you were a landlord, was when COVID first hit, because that tenant you had that had that stable job worked in a restaurant, and they can't work now. That period, and I believe, Don, weren't there laws passed by the governor that
That
protect?
there were.
Yeah.
Yeah, there were.
Well, and Mike, the problem we had was even if there wasn't a protection, the courts were so tied up, you couldn't evict someone even if you wanted to.
So, I mean, the point is, things happen. I mean, you might have the perfect tenant, the perfect lease and all that, but when you're a landlord, there's always variables there that, every now and then pop up that you didn't see coming.
Yeah, the longer the pre-occupancy, the more things that can go wrong.
Yes.
Yeah.
The only thing that you can guarantee is leverage. So if you give away all your leverage, if you don't do this little stuff, if you don't push, to get leverage in advance, then not only do you not have guarantees in the future, but you also have no leverage, which is, that would be a disaster. And by leverage, I mean having big security deposits, having a written lease, having the right to terminate, having, all these other things, these rules and regulations where if you don't do this, then I can kick you out. If you don't do that, I can kick you out. And not that I will, but I need the leverage. I need to be able to protect myself, my property, and then if I can, I'll help you out. I love it. Thank you for joining, you guys. I appreciate it. It's an interesting topic because I think it really does prove that you need to know the rental side, even if you are only doing sales. It's very clear to me. But if you need our help, feel free to contact us. Thanks, guys.